Welcome to episode 6 of This Week in Immigration, where we explore key issues and go in-depth on current immigration-related news. I'm David Lapan, the new Senior Director of Communications at the Bipartisan Policy Center, and I'm this week's guest host. If you missed our podcast on November 14th, here's a short programming note. We will be doing a new episode every other week until the end of the year. Subscribe to this and all of BPC's podcasts on iTunes, or stream on our website at bipartisanpolicy.org. For more information on what we've discussed today, or for more information on immigration policy analysis, visit bipartisanpolicy.org/immigration. To kick things off for today's program, I'm speaking with policy analyst Cris about criminal gangs and enforcement issues related to immigration and gang membership and activity. Cris, what are the key enforcement issues driving the immigration policy debate over targeting criminal gangs?
Thank you. So I think the thing that has been, at least in terms of crime, that has been really driving the debate is, the existence of the MS-13 gang, and a lot of news and media that people have been reporting about this gang, and the activities that they've engaged in. Most recently, ICE actually carried out a series of enforcement actions against MS-13 in order to detain and eventually deport these individuals from the United States. And this is actually the second phase of an activity they carried out that also targeted the gang in El Salvador, where they're originally from. So you have sort of this issue that's been driving this. The president has been very adamant about targeting this gang, and members of Congress have been as well. So you have that component, and so why is this important from a policy perspective? Well, it's important because there actually isn't a definition of gangs in the Immigration Nationality Act. It just doesn't exist. There is a definition of gang, and for instance, with the National Crime Information Center, they have a definition of gangs in that, but in terms of really defining criminal gangs in the INA, it just doesn't exist. Now, to be sure that there is any immigrant who commits certain crimes, including those related to gang activity, can be deported or barred from entry. And if individuals whom the government thinks that they're entering the United States engage in unlawful activities such as criminal gang activity, they can be prevented from entering, but there is no definition for gang in current immigration law that can sort of then impact how we deal with these individuals for affiliation, not for acts carried out.
Okay, and you mentioned the president and members of Congress. How specifically have they responded to this debate?
So, especially with Congress, what you've been seeing is that there have been two bills that have been introduced both in the House and the Senate that address these issues in their own way, in largely similar ways. Representative Barbara Comstock from Virginia introduced, and the House passed, a bill called the Criminal Alien Gang Member Removal Act. And what this does is specifically incorporating definition of gangs into the INA to basically create this as grounds for inadmissibility and deportation. Now, in this particular bill, they define criminal gang as an ongoing group, club, organization, or association of 5 or more persons, one of the primary purposes of which is commission of specific criminal offenses, and the members of which engage or have engaged within the past 5 years in a continuous series of offenses, and that has been designated as a criminal gang by DHS. Now, these offenses can include felonies such as drug offenses, harboring certain aliens, and crimes of violence. So that's what you see on the House side. But if you see on the Senate side, Senator Jeff Flake from Arizona, in the Border Security and Deferred Action Recipient Relief Act, so it's this fix for DACA providing permanent status for individuals who are DACA recipients or dreamers. He actually also incorporated similar language to Representative Comstock's bill. And that really largely looks at how criminal gangs can be designated by DHS, requires mandatory detention of immigrant criminal gang members, and there's also a call for reports on the number of immigrants detained under the gang designation provisions. But what's special and unique about Representative Flake's bill is that if you're a member of gang, found to be a member of gang, you can actually not gain asylum status, TPS, so temporary protected status, special immigrant juvenile visas, or other forms of relief from removal. So it's pretty interesting in the sense that there's sort of this additional weight carried for for gang affiliation under this specific bill.
And how have the immigration advocacy organizations responded to this legislation and these proposals?
They've been very critical. I think that the broad scope of their criticisms really revolves around due process and sort of the definition of gang and who can be put under that. So, I think that one of the concerns that they have is that law enforcement can really pretty easily label somebody as a gang member based on hearsay with little evidence or recourse. So, if an individual reports somebody else as a member of gangs, the bills don't actually have any recourse for you to say, well, no, I'm not a member, or I'm a former member, I'm trying to flee. So there's sort of that due process question that's also being brought in. And then obviously with Senator Flake's bill, the fact that individuals who are fleeing a lot of gang violence in Central America, who are then trying to claim asylum, that can complicate things if they're former members of gangs, but they're no longer affiliated, they want to leave that life. And so you have that issue related to due process and how you label individuals that I think is pretty, at least what the advocates are arguing is something that's really important to be taken into account when having these discussions about gang language and these bills.
So in a search for some middle ground between these proposals or between these positions, let's bring in Theresa Brown to explore whether there is common ground that we can find.
Hi, thanks, Dave. I think that, to the extent that the aim of these proposals to really go after criminal gangs, which are a scourge and have been, preying on immigrant youth and American youth for a while in this country, is something that has bipartisan support. The question really is how you go about it. And I think what Cris pointed to is that some of the issues revolve around how broad a brush you paint. Really, at the base of this issue is the fact that there's not a standardized definition or way an individual can be named by law enforcement as being a member of a gang. It can be based on a criminal informant saying so. It can be based on a law enforcement officer believing they've seen somebody near or interacting with somebody who's a member of a gang. So based on that limited information, a whole host of immigration and other consequences can come forward. I think if we can focus back on the idea that we want to aim at those people who are engaged in criminal activity, including conspiracy to commit criminal activity, which a lot of gangs are, and really focus in on the activity rather than this vague idea of membership, you might be able to find some common ground between advocates and enforcement folks. But that's going to require some negotiation and some conversation. Cris mentioned that Representative Flake attached this to his DACA bill. I think that's probably going to be difficult to negotiate that kind of a deal right now because the nuances of this matter. We're talking about, what does our immigration deportation system look like and how quickly can people be deported and whether or not they have the ability to challenge one of these gang designations. That's kind of a lot to deal with when we're trying to fix DACA at the end of the year. So we'll have to see how well they can come out. And frankly, advocates haven't been all that eager to offer other solutions. So we have to figure out if there is a middle ground, where it can be found, and can we find it quickly if we want it to be part of something this year.
Well, this issue of criminal gangs will certainly be with us as we move into 2018. You mentioned DACA, so let's shift and take a look at more recent news and court actions related to the Deferred Action for Childhood Arrival Program,
That's right.
Commonly known as DACA. So, Theresa, would you just update our listeners on the recent controversy over U.S. Citizenship and Immigration Services rejecting DACA applications that were received late after the October 5th deadline?
Right. So backing up, you may remember that when President Trump terminated the DACA program, he said that anyone whose DACA authorization would expire within the next 6 months, as in before March 5th, could file for one last renewal as long as they filed by October 5th. So there was a 1 month window when people who would expire within that 6 month time frame could file their applications. But the application, USCIS said, had to be received by October 5th. Now, that is actually a change from where most deadlines, how they interpret most deadlines. Usually USCIS says it has to be postmarked by a deadline, but this was very clear. It had to be received by USCIS by October 5th. So a lot of people scrambled very quickly to raise the fees, to get all their documents together, to file these, and many people, perhaps as many as 4,000, filed and mailed it in time to be received, but it didn't quite make it, in part because the post office acknowledged that they had some issues in Chicago and a couple of other places with their delivery. So it was a post office problem, not the applicants, and that in some cases the applications actually had arrived on the 5th, but USCIS didn't come pick them up from the post office lockbox until the next day. So this issue was raised to USCIS, and lo and behold, they said, okay, we understand there was an issue. So they allowed people who believed their cases were in that category to reapply and make their case that it was wrongfully rejected. So we don't know how many will actually reapply. We don't know how many will be accepted if they reapply, but at least there's some acknowledgement on the behalf of USCIS that there were some people who were rejected that maybe shouldn't have been.
Okay, and is that something that came from the president? Did that come from the acting secretary of Homeland Security? Where was that decision made?
Well, the notification was given by Elaine Duke, the acting secretary of Homeland Security. So unclear if the White House weighed in at all on this. I know there was some conversation about other issues that the White House has weighed in with DHS. But on this one, it seems to be a decision made within DHS. At least the acting secretary has said that they would reconsider it. So USCIS now has been saying this. Notices have been put out. The question really remains how individuals will prove that they mailed things on time, that they were one of the ones that was improperly rejected at the lockbox. It's unclear what evidence USCIS is going to need, and again, unclear. They just said that it would look at it on a case-by-case basis. So some of these cases might get rejected again. We just don't know.
And to that end, explain. Well, I mean, some of this is very obvious of why this is important, but especially for those who believe that they had met the standard and had sent in their application and just weren't, they didn't procrastinate.
Yeah,
or they
did
didn't,
everything
just wait too
right.
long
It's not my fault, right?
Right.
As I said, these are people who were given essentially one last chance to extend one last time their DACA protections. And DACA protections, let's remind everybody, mean employment authorization, so their continued ability to work and be protected from deportation. So without this, without these extensions, they most likely would be losing their status sometime between now and March 6th, which means they would lose their jobs and they could be picked up by ICE for removal at any time. So this is important for them. And they really worked hard, again, in a compressed time frame to put this together. And so I think there is an issue of fairness for these individuals that did everything right and on time. We also know that as many as 40,000 who could have been eligible didn't file. Based on USCIS records of who they believe would have been eligible in the 6-month time frame, there is some number of individuals who did not get their applications in on time at all or didn't file within that 1-month window. So there are DACA recipients who are starting to lose their status already now. But this is a group of people, a smaller number admittedly, who actually did everything right and are still hoping they can get the benefit.
So this particular incident involving, again, late applications and rejections and now reconsideration of those point to some of the complications there are with winding down the program, as the president laid out. At one point early on, I think on the same day that the announcement was made, the president tweeted somewhat cryptically about, if Congress doesn't come up with a fix, then he might take action. Any sense of what that means adding to this complication or as a way to resolve it?
Well, what we see from this incident with the U.S. Post Office is that, as you said, once a program is put in place, winding it down has implications, right? It has implications for figuring out how long can you file, when do you have to file by, when do people expire, do they have a right to appeal, any of those things. But once a program is terminated, the same considerations go with revving it back up again. So if the president has terminated the program, as I said, there are people who are losing status right now. even if he were to turn around March 6th and say, okay, well, I'm going to restart the program, USCIS will have to renew, once again say, okay, here's who qualifies, here's the forms, here's the resources we're going to put to adjudicating that. Let's reopen up those lockboxes where people can file those fees, and let's put out the notices in the Federal Register and everywhere else. That takes some time. It doesn't just happen overnight. And anybody who's already lost status, would they be able to reapply? Or have, since they failed to lose status, are they no longer eligible? All of those things will have to be figured out, policies and procedures, as to how people can get back into the program if he were to restart it. And that could take us up several months. Let's say the other case, Congress actually does pass something, but what they pass looks different from what DACA was. Maybe there's new requirements and new eligibility things. That means USCIS has to now figure out, well, did our old forms work, or do we need new forms? Do we need to ask different questions? How do we determine whether somebody meets the new eligibility criteria? What evidence do they have to present? What's our discretion to approve or deny? They have to issue policy guidance to their adjudicators and notices out to the public. How much should we charge as a fee for this? And how do we collect that? All of that has to go through a process. It may or may not require regulations. That could be 6 to 8 months. So regardless of what we're talking about, whether the president were to restart the program or Congress were to create a program, there's a gap, and there's a time needed operationally for a new program to get up to speed. And that's one of the reasons why a lot of people are pushing for Congress to act as soon as possible, because the earlier they act, the fewer people will get caught without status and having a gap.
Okay, so let's tie that together. Again, a great desire by many folks, really on both sides of the aisle, to resolve this before year end, with lots of other political issues on the table. But at the same time, you have court actions that are also affecting this. So can you talk about some of the lawsuits that have been filed against the administration regarding the way DACA was terminated?
Right. So the administration has been subject to at least 2 major lawsuits in federal court alleging that the decision to rescind DACA or terminate DACA was made without due process under the Administrative Procedures Act. There wasn't enough notice. There wasn't opportunity for comment. It was done without due deliberation and maybe done arbitrarily and capriciously, which are 2 legal terms that matter under the Administrative Procedures Act. So there have been some plaintiffs that have filed against the administration in court asking for an injunction against the termination, which would mean if those injunctions were granted by the court, the previous termination action would be reversed. The program would have to be restarted, again with all of those operational considerations, but would have to be restarted. And quite possibly those who have already lost status would have to retroactively be given that status back, depending on how the injunction is played out. The courts have not yet ruled on that injunction request, but in the process of doing so, the courts have asked that the Justice Department and DHS turn over documents in discovery that would say how they came to the decision. How did the president come to the decision to terminate? And they believe that's relevant for determining whether or not it was done, again, contrary to the law, arbitrarily, capriciously. The Justice Department has said it wants to appeal the court decision requiring they disclose these documents. They argue that it's part of presidential privilege, they're pre-decisional, the court should not have access to them, and neither should the plaintiffs. And they prepared to take that part of the case to the Supreme Court. Well, just this week, the advocates who filed the original court cases went back to the original court and said to the judge, you know what, never mind, we don't need to see those documents right now, because if that fight goes to the Supreme Court, it will take longer for us to get back to what we really want, which is to decide whether or not we can get the DACA program back. So they've asked the court to not proceed with that and to go back to the original case. So what this means, honestly, is that it may be a little while before any of these cases result in a decision that will actually affect the DACA program or the DACA recipients themselves. We just, we have to wait and see. But it tells us something else, and that is this administration is going to fight to support the decision it made. They were willing to take it to the Supreme Court, and they were willing to say to the Supreme Court, nope, you don't have a right to see our decision-making documents. Given that this administration is being sued on several other immigration-related frames, it's important to understand this dynamic. An awful lot of the decisions that this administration has made on immigration are being challenged in the courts. Some of them have gone to the Supreme Court, not had full decisions yet, and they're continuing to be litigated. At some point, this decision may or may not become moot. If Congress asks, then it may become a moot case if they act. But at the end of the day, what we're finding more and more is that really fundamental issues of who has authority to do what in immigration law are being challenged in the courts. This debate between what Congress has to do, what the administration can do, how the administration can do it, it's being fought in the courts. And that is going to have very serious implications as these decisions come down for future immigration actions on any administration.
So what I'm hearing, though, is that, again, based on the fact that the administration has been fighting back for its prerogatives, that it's probably pretty likely this case could wind its way to the Supreme Court as well?
This case probably will end up at Supreme Court. I don't see this administration taking a decision that goes against it at a lower court and leaving it there. My bet is that they will take it up to the Supreme Court and argue it there. And they now have 9 justices. The last time they went up, they didn't. And they'll take their chances there, and we'll see how it comes out.
So how likely is it that all of these various legal maneuvers might have an impact on Congress legislating a fix to the program?
Well, right now, Congress is so fixated on what they're fixated on, which is funding the government for the end of the year. The Republicans really want their tax reform. Yes, some of them are focused on DACA. They're not paying a lot of attention to the court cases, I don't think. And frankly, as I mentioned, if Congress were to act, that might moot out these court cases, and we now have a new program that we'll have to look forward to. I think at the end of the day, for those who are in the DACA program and who are looking for some answer for themselves, I think the most immediate term answer is likely to come from Congress if they're able to legislate by the end of the year. If that falls apart or that fails, then yes, the court cases might be the avenue where they find relief. We'll have to see.
Okay, well, thank you for taking us through that, Theresa. I expect this is certainly not the last time we'll talk about DACA before the end of this year.
Nope.
Thanks to you and Cris for both joining us for the podcast this week. To find more of our analysis on immigration, go to bipartisanpolicy.org or find us on Twitter at BPC_bipartisan. And don't forget to rate, review, and subscribe on iTunes by searching Bipartisan Policy Center. Thanks again, and we'll be back in 2 weeks.